Hi guys. It takes a few days to process, but I think I'm an affiliate on Twitch now. So if you watch my live streams, this is only for live streams, and you get ads, then you can go to Twitch and watch it with no ads if you're a subscriber. And this is how you get your free subscription. You can get a free subscription to my channel if you have an Amazon Prime account and you link Twitch with Amazon. Then you get one gift subscription to one channel on Twitch a month. You got to do it every month. You can just go ahead and link it and then use that one free subscription for my channel on Twitch. And nobody else is on Twitch that I know of, so it, you can use it there, and then you can watch that for free. Now, what I don't know is the last couple they keep. All right, so there's 3 right now. I don't know if you watch these as replay crew on Twitch, if you get ads. I think if you use that sub, you don't get ads for lives and replays, but I'm not 100% sure about replays. You get ads on both on YouTube. So if you don't want to see ads, there's a way around it. They haven't sent me my notification that I'm an affiliate, but I did all the requirements, so it's just a matter of time now, I guess. So we're gonna start Anna's on Twitch right now. We're gonna start with Jersey. We're gonna go to New Jersey first. It's not crazy. It's just Nakama. We haven't seen him in a while, so let's watch Nakama.
What's your name?
Riyad Mohammed.
The matter of Riyad Mohammed, W2025-0001090704, have entered not guilty plea for you. Your public safety assessment calls for no release. Mr. Prosecutor.
Yes, Your Honor. So in this matter involving allegations of shoplifting coupled with hindering, it is the intention of the state to refer this matter back to the Fairfield Municipal Court. So therefore, we will not follow the recommendation of no release. I will inform this court that the defendant before you is currently an active level 3 out of Passaic County, and he has been deemed to be non-compliant. However, given our determination to refer this case back to the municipal court of Fairfield, we will return or concede to return Mr. Muhammad to level 3 weekly reporting with the hope he'll be more compliant. We ask for no contact with the location of target, located at 632 Route 46 East in Fairfield, New Jersey. Thank you.
No objection from the defense as to those conditions of Mr. Mohammed's release.
I will order that you be released today under the following conditions. You must appear for all your court dates. Notify pretrial services of any change in your contact information. You shall not commit any offense during the period of your release. You must have no contact with the alleged victims of this offense, their residence and their places of work, and you must stay 500 feet away from the target located at 632 Route 46 East in Fairfield, New Jersey, and cannot make any contact with those that transact business at that location. You must also report to pretrial services by telephone once every other week and in person once every other week. Your next court date is September 11, 2025 at 2:30 p.m. at the Fairfield Township Municipal Court. And you can apply for a public defender. when you go to that court. Do you understand?
Yes, I do.
You can leave the booth now, please.
Quick question.
Yes.
Is there anybody I can speak to?
About what?
I want to know, so you releasing it right now?
I just finished saying that.
Huh?
I just finished saying that I've been speaking to you
Okay,
for the past
no.
3 or 4 minutes.
And sir, now you know what it's like to be married. Now he knows exactly what it's like to be married.
No, I understand that, but the thing is, I have a warrant out, right? But I was in rehab, and
When you
I don't know.
leave the booth, you will discuss your warrants with the officers.
Thank you.
Can you please leave the booth now? The matter of Josue Rosario, W2025-008244-0714. What's your name, sir?
Joshua Rosario.
I will enter not guilty plea for you. So that first name is Joshua. Your public safety assessment calls for bi-monthly reporting. Mr. Prosecutor.
Judge, thank you very much. So, Your Honor, in this matter, involving allegations of narcotic possession together with distribution, we have no objection to the recommendation and imposition of level 2 bi-monthly. We will seek the usual CDS prohibition. Thank you.
Any objection?
None from the defense.
I will order that you be released today under the following conditions. You must appear for all your court dates, notify pretrial services of any change in your contact information. You shall not commit any offense during the period of your release. You must refrain from excessive use of alcohol or any controlled dangerous substance without prescription by a licensed medical practitioner. You must report to pretrial services by telephone once per month and in person once per month. Mr. Prosecutor, is this matter going vertical?
It is, Judge.
So this case will proceed before Judge Fuentes on September 5th, 2025 at 9 a.m. Public Defender Owens has been assigned to represent you. Do you understand, sir? Mr. Rosario, do you understand the conditions of your release that I just explained to you?
Yes.
You can leave the booth now, please.
All right, thank you.
You're welcome. The matter of Michael Santiago, W2025-008272-0714. What's your name, sir?
Michael Santiago.
I will enter not guilty plea for you, Mr. Prosecutor. Is the state requiring an alternate address?
We are not, Your Honor.
Your public safety assessment, sir, calls for monthly reporting. Mr. Prosecutor.
Your Honor, thank you. So this is a matter of domestic violence, specifically allegations of strangulation. This defendant is the victim cross-complainant of Ms. Arvanitakis, who was previously heard in this court. With respect to this matter, Judge, again, we do not seek an alternate address. However, we would note that we concur with the recommendation of level 1 monthly reporting. We ask that there be no contact with the victim, again, cross-complainant, Ms. Kristen Arvanitakis. Thank you.
No objection from the defense as to those conditions.
I will order that you be released today under the following conditions. You must appear for all your court dates. You must notify pretrial services of any change in your contact information. You shall not commit any offense during the period of your release. You must have no contact with Christine Avanitakis, their residence and place of work, and cannot communicate with them in any other manner. You must report to pretrial services by telephone once per month. Your next court date is September 5th, 2025, 9 a.m. before Judge Gizo. Public Defender Bellamy is assigned to represent you. Do you understand?
Yes, I do.
Give me 1 second.
That was it. That was it. That was it. I forgot that was just the quick one. Now we're going to go to California. Child support. California.
Mr. Ogas, Ms. Tuttle.
She does not win $300,000 in child support. Just telling you that now.
Good afternoon.
Yes.
So when I reviewed the file, there were no pretrial statements. I now see that there was one filed July 11th by the father. For some reason, that never made it into the court file until today. Did you both get the updated audit?
Yes.
Yes, sir.
Okay. Is there still a problem that we need to talk about?
Yes, sir, because that audit, I just received that today for the first time seeing
Yeah,
that.
me too. Me too.
And it contradicts everything that I sent you in my pre-statement, my pre-trial statement.
Let me see what I can find here.
And I did forward everything that I forwarded to the courts. I forwarded to Dan Tuttle and to DCSS.
Mr. Mills, is all of this money going home?
Your Honor. This case was in Placer County for a lot of the period of time. When enforcement was going on, I believe we opened up, or Mother asked us to enforce starting June of 2024, I believe.
Yes. Looking at a case audit report dated 7/31/24. The first page of it starts May of 2013, goes through January of 2015. It shows payments due 5 months, payments received 2 of those months. The next page that I have says page 2 of 9. Oh, and the total amount of arrears at the
Thank
top
you.
on the first page.
That's like a super chat in Twitch. Fozzie cheered in Twitch. Wait, I didn't realize it. It didn't. So I didn't realize that. That's another cheer Fozzie did in Twitch. Hold on. Did I miss any more? No, I don't think so. 2 cheers. I don't see any more. They didn't show up the same, so I didn't know. 1, 2. Get out. Hello, Jude. Thank you. And thank you for donating the first Prime sub. That was awesome. Nan, right?
Is a bunch. I mean, $131,499.37 principal. Interest balance $70,344,014. The next page, 2015, 2016, ending balance, 0. The next page, 16, 17, and 18, principal and interest balance, 0. Continuing on page 4 for future years, page 5 for future years, page 6 for future years, all say 0 balance, without any indication as to what happened to the couple of $100,000 worth of arrears. Can you tell me what happened with that, Mr. Mills?
I believe those are the years.
And just like that, I was wrong. Is he really missing a couple $100,000 worth of arrears? Really? All right. Hold on. Let's listen. Hold on.
The case was closed. And then it was reopened in June of 2024. And we began the process of setting the accounts. And this is where we are now.
Well, so for June and July of 2024, it still says principal balance 0, interest balance 0.
Well, I believe because there was a disagreement or we did not receive information that would allow us to prepare the audit.
So your case closed back in 2013? Ms. Tuttle, did you close the case with DCSS?
William and I had an agreement and follow through with the agreement. So I reopened the case in Placer County and they moved it to Sacramento County.
And then what's the purpose of the birth certificate, Mr. Ogus?
I put in there that there's 2 of my biological children that are in this order, and then 2 of children that are not biologically mine in this order. I just wanted all the facts to be out there, sir.
Hey, Judy.
Fortunately, I don't have the full file. I have a registered case from Placer County. What they registered was, let's see, a family law judgment. Dissolution judgment from 2004. It identifies, starts with property, interestingly. And it identifies all 4 children as children of the parties. Doesn't indicate that anybody was present. It says it's by declaration under Family Code Section 2336. Joint legal custody. With visitation, child support. Child care. And this is signed by both of you. March 1st of 2004. Yeah?
Yes, sir.
I missed some. It's in a different spot, and I didn't realize because I'm looking at my regular stream. Tina, thank you for the gifted sub that you gave on Twitch. And then Fozzie's 2 cheers. And then Fozzie subscribed with Prime. Good idea. That's free. And then Maria cheered. Thank you so much, Maria. On-screen celebration. I didn't see it. I don't know how to see it. Maybe you guys saw that on Twitch. I didn't see that. Tina, 3 days ago, a gift sub. I didn't see that. 3 days ago, Fozzie, on-screen celebration. Fozzie cheered 3 days ago. Tina subscribed with Prime 3 days ago. Fozzie gave out a gift sub 3 days ago. I think I got them all. I didn't even know that screen was even there. I just saw it right now. So now I'll watch it. Thank you. Thank you so much, guys.
Yes.
Okay.
This is the first time he's at parentage.
I'm
It has
first.
never issued before today or
I don't know where
before
the sounds went. Hold on.
his letter that he mailed to the court. They all have his last name.
4.
I don't know where my sound is.
Child care.
Just checking. Do you guys hear anything right now?
And this is
All right, I'm gonna
signed
all right.
by both of you.
It hasn't happened so long that I forgot. I forgot that it does this every once in a while, and it's been a while. We're fine. Just give me a second. Boom. Oh no. There we go.
March 1st of 2004. Yeah?
Yes, sir.
Yes.
Okay.
This is the first time he's at parentage.
I'm
It has
first.
never
Hold up.
issued before today or before his
No,
letter that he mailed to the court.
I
They
don't
all
hear any
have his last
I
name.
need to be able to hear.
He's on all of their birth certificates. This has never been an issue.
Oh, he is on their birth certificates?
Yes, Your Honor.
Were you married when all 4 children?
We were
Were
married for
you
3
born?
of them. We were married for 3 of them, but we were in a relationship for the 4th as well. We just weren't married
Okay.
until I was born.
But according to the judgment, you both have acknowledged that all 4 children were children of this marriage.
Correct.
Okay. So that's a non-issue. Okay, and then the audit starts back in January of 2004. Mr. Mills, does CSE reflect any payments ever being made through Department of Child Support Services?
According to Placer County, there were no payments made through CSC, and then we picked it up in 2004 based on what they advised us.
And the only payments that I see being received were in August. In September of 2013. And those look like they were intercepts of some kind. Maybe bank levies. So, sir, you do understand that whether DCSS is involved or not, there was a court order for support.
Yes, sir. And
Their involvement would only have an effect on who's enforcing that order.
correct. And I did send in a declaration of
Direct pay.
yes, sir. A declaration of support payment. I sent that in on 12. Sorry. On 12/9 of 24. And I forwarded that to Veronica Porter, the case handler of my case. I've mentioned this to her 3 times, asking her if this has been taken into consideration for this audit that they were going to do. And then I got the audit today showing that they hadn't.
Okay, so
I think we might have missed some. I hope you can hear me. I think this is Mom's attorney. I think Mom is in the room. This is Dad. I think they came up with an agreement to pay child support outside of DCS, and then Father never paid. So Mother reopened another case. So she had said that he had not paid any child support. I think he's saying now that he did pay, but then he also says that, well, they never took it out of my check, so I thought I was fine.
hold on. Your Exhibit E, Mr. Ogas, is her declaration of support payment. It appears that she put all zeros, and then there's other numbers here right next to the zeros. Are those your numbers? Did you put those numbers on there?
I was calculating it. Yes, those are handwritten numbers that I calculated.
Okay, so that's not her information. That's your information.
Correct. So that there was me showing that she opened the case with all that showing as arrears, and then she closed the case, and then everything was great from 2013 to 2024. And then all of a sudden she opens the case again and I owe arrears for all the way back to 2004 again. That's the reason that paperwork's in there, showing that she opened it and then closed it.
Which is not to say that you made payments. It's to say that she was closing your case, DCSS wasn't trying to enforce.
But I did state in my pretrial statement that I have made payments directly to her, that DCSS was not in charge of tracking. And I put that there, and if they ever take my declaration of support payment into consideration, that would benefit me as well.
Declarations are great, but money.
Well, you've got this
Money
case
is
audit
great.
report on here twice. So that's taking up a bunch of space. And this one says the same thing as the last one, just
We've seen her before, and we've seen him before, and we've seen him before. There are three of the normal players in this courtroom. Mom is off screen. We've never seen her before. Dad, he's new too.
the two payments are reflected.
No, I sent 2 copies because I thought they were going to stamp a copy and send me a copy. So there's probably 2 copies of what I sent to them.
Now, well, I mean, they're 2 copies of your exhibits, but, and your declarations. Yeah, it's all stapled together.
Yeah,
So
I
it
had sent,
appears to me to be just one copy, but
right.
it isn't.
When I sent it in, I had it with a thing that said copy, and the original was on top. So I wanted to make sure that I thought I was going to get something back when I sent that in.
One thing that I didn't note in all of those exhibits is your direct pay history. Did you provide one to DCSS?
I did on 12/9 of 2024.
Mr. Mills, do you have that?
He's never paid,
Do not,
so he didn't give a history, Judge. He's a liar.
if we have, we would have,
Well, you would have at least had it for me to look at today.
Right.
Ms. Tuttle, did you get a copy of his direct pay history?
No, sir, I did not.
He's not
Okay.
even pretending to.
There's
look at it.
nothing in the pretrial statement that you filed other than saying 2 of the kids aren't your biological children. They should be taken out of the case. And she was opening and closing the case. And so you want the whole thing to be dropped.
And I showed proof that audit back in July 24, that everything was 0.
Okay.
actually, Your Honor, we do have his pay record, and Mother's pay record contradicts it.
Can you send a copy of that over to Joseph?
Sure.
I want to see.
And this is not the first time he's seen an audit. I believe he received an audit, which was, I think, generated the objection to the registration. Because we had done an audit earlier, and that audit is an updated audit.
Okay.
The audit that was received today, that's the first time I've seen that.
Yeah, me too.
The one that was done in May, that's the first time I've seen it.
Yeah. So the interest is more than half of this. It's about 60% of it.
Tell us a number, Judge. Give us a number, please.
Sent, Mr. Mills?
Well, he's got several, so and I can't put them together. So,
He's got several direct pay histories.
well, he has one pay history for 2013, and then he's got another one for multiple years.
While he's doing that, Mr. Klink, have you guys met and conferred?
I'm sorry, Your Honor.
Have you guys met and conferred?
Repeatedly, Your Honor, but I mean, we could try again. I usually am met with silence.
Okay. And you've got, let's see, another hearing August 13th and 121, and then a settlement conference and trial toward the end of August.
Yes, Your Honor.
You sure you don't want to include this in your settlement conference and trial?
I'm sure, Your Honor.
Well, thanks a lot. I'll remember that.
Yeah.
Yeah.
I wouldn't mind to meet confer. That's not an accurate statement.
Okay. There's a room right outside there if you want to go.
Great.
Have a seat.
Thank you, Your Honor.
Everyone present, please.
What's that?
His client present, please.
Well, that's really up to them.
He doesn't need to be present.
I would like them, or else I don't want to.
Well, I mean, obviously, he'll ultimately be making the decision.
Yeah, I'll make the decisions.
I need him to hear what you speak. Otherwise, I don't.
I'm sorry, I can't hear what you're saying.
If he's not
She wants him to hear what she has to say.
I want him to hear.
Oh, she wants him to be present. I thought
I want him.
No, she wants him there.
Oh, okay, that's.
Okay. There's a room. And ma'am, you are?
I'm a real-time
We did
capture
see
here
those
for an
two.
accommodation.
Those two that are leaving right now, these guys, we did see them. We did.
From still.
Okay. Mr. Klink, any problem with that?
No, no problem, Your Honor.
Perfect.
Are we doing this?
How many pages is it, Mr. Mills, total?
That's 4 of them.
Ah. 4 of them, 4 pages.
4 different pages.
Yeah, okay, that's fine. I can handle 4 pages.
I don't know if he's paid any child support since 2004. I just don't know. But I do know, even if he hasn't paid a dime, I'm going to get all kinds of chats saying that she's taking him for everything he's got. Sounds fine. No one's talking. Your sound is fine. Judge Ponder went to California. Oh, I'd like to see Judge Eric do these kind of cases too. No, Ozzy, you don't understand. I keep trying to tell you, but you're not listening. I only can choose 4 more. I'm only allowed to have 5. I uploaded 1. I can only put 4 more on. How am I supposed to pick? We can't do per mod because I can only choose 4 mods. I'm not choosing 4 mods. 4 more. That's all I can do. I'm going to fast forward it and watch. I'm going to miss a whole bunch. Then I'm going to have to rewind it. What's going on? Oh, he's waiting for him to email those 4 freaking pages. Wait, I think we're there.
What's missing is 2,000.
Right, because that's, I don't believe he gave us anything beyond that.
What's missing is 2,000 8, 9, and 10. I know, I'm sorry. 10, 11, 12. 10, 11, and 12. Although
October
if it's
20th.
the same, if it's the same as all the rest, what all these are showing is that you made every payment. In fact, it even looks like you overpaid on one occasion.
She's taking him for everything he has.
So you're saying you never missed a payment?
I paid every payment. And the youngest child was emancipated in 2014, October. That's the reason there's nothing after that.
Hold on.
Well,
now,
no, I
let
get
her
it.
talk.
There would be no balance after that if you made all the payments. There would have been nothing to pay. The concern is that there were periods of time prior to 2014 when DCSS did have an open case, right, Mr. Mills, Placer County?
Are you saying after 2013?
No. Between 2004 and October of 2014, so did Placer County ever have an open DCSS case during that 10-year period? Almost
Yes.
11-year period. I'm asking DCSS to see what their record
Right.
shows. I mean, I believe that that's the answer, but I'm waiting to hear Mr. Mills tell me that that's the answer.
Sorry, Your Honor.
I will tell you what the audit instructions are indicating.
I don't think the audit is going to show when the case was open and when it wasn't.
It will tell us what Placer County told us, though, because we just did the audit of what they told us.
So I get that it'll tell you what Placer County told you about payments that they received. I'm trying to find out what period of time they actually were attempting to get payments when they didn't receive any. I've got something from his pretrial statement at the very end of the documents from the mother. The date of it is 9/24/13. It's a voluntary case closure request. It says, William Ogas and I are going to work on this without involvement of a third party. So that's the closure, suggesting that before that it was open. I just don't know for how long.
We have log entries up until 2008. Then there's one log entry in 2010, and then they start again on July of 2012.
The log entry meaning that the case is opening, it's closing, or it's just somebody made contact with DCSS.
What are all those files?
But I think it's, well, it is.
This zone says 10.
Well, there's the log entry in July of 2012 said Miss Ogas still wants to pursue for child support. What was running before that were just converted entries because we had a different system back then. They were keeping track of the emancipated children. Telephone call to custodial person in 2006 to see if she still wants case open, as it was a Medi-Cal case only. And she discontinued Medi-Cal in August of 2006.
So at least at that point, DCSS was not enforcing. They just kept it open for Medi-Cal.
Judge, you're going to have to speed this up a little bit. Judge.
Is this difficult to ascertain when the Placer County DCSS had an open case?
Well, for Placer County, and it was running on a different computer system. It's not like the computer system we run now where I can see what the log entries are.
When did CSE open up? Early 2000s? Oh, no. Yeah, that's what I thought so.
This is all co-stars. Employment verification search in 2005. So we're still looking for money at that point.
Well, and we certainly know that she did a voluntary case closure in 2013. So it was open before that.
She gave you all
Yes.
of her bank account.
And ma'am, do you remember when you had the case open with DCSS?
I don't, Your Honor.
Was it more than once that it closed and reopened?
Yes. Because he keeps making verbal agreements with me and then not following through.
Yay, thank you, Fuzzy. Thank you.
Were his promises, were among his promises that he would actually give you money?
Honor.
I didn't understand that.
I've never received money from him, Your Honor.
Yeah, that wasn't my question. The question was, did he promise to do something other than just give you money?
No.
Okay. So you thought when you closed the case that he was going to start paying you?
Yes.
So when you closed the case and he didn't pay you, how many months did it take you before you went back and reopened the case?
It was several years.
So the last time you closed it, at least the one time I have a document that says, we're going to try to work it out among us, we don't need your help, that was 2013. Do you remember how long the case was open prior to that closure?
I believe it was immediately after we were divorced.
And the divorce was in 2004 when all of this started.
Correct.
But it wasn't open all the way from 2004 to 2013, was it? Or was it?
Yes, it was, Your Honor.
Oh, so for 9 years, DCSS in Placer County was trying to enforce?
Yes.
Oh. Okay. So, sir, what we have is DCSS supporting the mother's information about what payments were received. Are you saying that you made payments directly to her, or did you make any payments through Department of Child Support Services?
I made payments directly to her because we weren't enforced by Department of Child Support Services. She didn't open that case until 2013. If you look at the sheet on Exhibit E, her case was opened that date on that one where she was doing her declaration of payment, where she was saying I paid zero, and that's the date that it opened. That's the date that Child Support Services got involved and started to enforce. And the only way that I found out about that is they started a payroll deduction.
So they got payments out of your paycheck?
Yes, in 2013.
And according to their audit, that does not reflect any payments.
Yeah, Judge, it's because he's lying.
I'm sorry, 2. August and September of 2013 were the only payments reflected by DCSS.
Wait,
And
you
I
mean
believe that
more?
on the site that I log into, there's 4 payments because there was 4 payments drawn from my check. And then she went back and had them close the case with that closure that you have in Exhibit E.
Yeah, the closure is dated in September of 2013, so it may be, and it may be that there were a total of 4 payments made over the course of 2 months.
Correct.
They don't show each individual payment. They showed total in 2013 of $1,154.94. That could have been 10 payments for all we know. But you're saying that there were a total of 4 payments made during those 2 months.
I believe so, yes.
Okay.
But outside those 2 months, I have never had to pay through Child Support Services or anything else. Nobody's deducted out of my paycheck. I've been employed the whole entire time.
And so how did you make your payments?
I wrote checks to her.
And do you have copies of any of those checks?
No, sir, I don't, because when I received that letter that I owed zero, and then I went through moves, I have lost those documents. I had put that letter in my file, and all the return or the checkbooks that have the carbon copies and everything, I don't have those any longer.
Where did you bank?
Bank of America, and it's by federal law that they only have to keep records for 7 years.
Yeah, no, I know that.
So I'm having trouble proving that point.
Well, no, I mean, I understand that B of A does not go back that far. And at this point, we're talking about from the time when the support stopped being charged, which is 2014, that's more than 10 years. So okay. Is there anything else that you want me to consider before I make a decision, Mr. Ogas?
No, sir.
Ms. Tuttle?
No, sir.
Okay, what I'm going to do is, because I just did get the pre-trial statement today, I have thumbed through it, but I want to spend some more time looking at it before I make a final decision. So I'll take this under submission.
Thank you.
All right, that's all for today. Thank you.
She is absolutely not getting hundreds of thousands of dollars in back support. Because if she waited too long, there's no way to prove it. There's no way for him to prove that he didn't pay. So she's gonna lose. And I don't know about those 2 kids that were not his biological children. I don't know if they were put on after I mean, if they were taken off after like years later, he's like, yeah, we should do a paternity test on those two. Or if she was already married before they got married, had 2 kids, I don't know. But we're going to Colorado next. We're going to end in Colorado. I think this is Eagle, but I'm not 100% sure. Oh my gosh, it's Eagle. Yeah, it is. It says so right here.
Mr. Trailer, can you please state your name for the record?
Jason Trailer, Your Honor.
Mr. Trailer, did you have a chance to watch a video that advised you of your rights?
Yes, Your Honor, I did.
Do you have any questions about those rights?
No, ma'am, I do not.
Mr. Short, are you appearing on behalf of Mr. Trailer for the purposes of bond today?
I am, Your Honor, and I would waive further advisement by the court on this matter.
Thank you. Would the people like to make an argument for bond?
Honor, thank you. Mr. Trailer has no criminal history on the summons, even though it indicates that he was living in this employee housing. He has a Breckenridge address. But for the allegations of threats to these 2 roommates, I would have asked for a personal recognizance bond, but because of those alleged threats, the people are asking for $1,000 cash surety. The roommates, at least one of them indicates they have safety concerns and fear of retaliation. So that's the reason for the people's request for a cash surety bond, please.
All right, are Joshua Tennant or Max Van Gildenstube, is that both of you?
Yeah, that's us.
Would you, either or both of you, wish to make any statements?
Okay, first of all,
Hold on, we're making a record, so you need to come to the podium.
Okay, well, his name is not Jason Trailer, it's Jason Taylor. He's lying to you right now.
All right, keep going.
And, I'm really concerned about the guy's mental health. Like, he terrorized the both of us all night long for absolutely no reason. And I want a criminal protective order against him.
All right, noted. Okay, and would you like to, and your name is?
I'm Joshua Tennant.
All right, and would you like to make any statements, sir?
Yeah, it's the same thing, right? Yeah, I'm worried about his mental health. Like he told us multiple times, he's an Army Ranger. So he's really experienced guy. And if he says something like he wants to cut somebody's throat, we have to take that very seriously.
All right, thank you for that. Mr. Short?
Your Honor, understanding these are accusations at this point, and the bond statute with somebody who has no criminal history creates a certain presumption, and it sounds like the people are asking the court to overcome that presumption. We would just like the court to consider the fact that Mr. Trailer has spent the last 12 years in Colorado. He's a way to get to and from court. Unfortunately, given his financial situation, he does not have the financial ability to pay a bond. When I spoke with him, it sounds like he did live at the employee housing. I can't rectify that difference that Mr. Kerwin brings up about the Breckenridge address, except to maybe think that it's employee housing. So someone might have a mailing address somewhere and an actual address somewhere else. But I don't know why that might be. Otherwise, Your Honor, we're just asking for you to impose a personal reconnaissance bond given his financial condition. I don't know if the court has something like bridges or pretrial mental health like we have in jurisdictions on the Front Range. But those programs sound like they might help assuage some of the concerns expressed by the people and the victims. And I think if the court were to also impose sobriety monitoring, then we would know some more about what's going on with Mr. Trailer. I didn't ask Mr. Trailer whether he was a veteran, but if he is in fact a veteran, I would ask the court to take that into consideration when setting his bond. But unfortunately, that was something I left out of my questions because I was running out of time. But otherwise, Your Honor, we're just asking the court to follow what we've asked the court to do.
So for the roommates, was drinking involved in this situation? It was.
We fill up paperwork on the outside,
Okay.
so I don't know.
You'll give that to the prosecution. So what you're gonna wanna do after you leave here, if you head back out of the courtroom, and then the building right next to this building, when you walk out of the front doors, if you'll just to the left of the building, that's the prosecution's office. You'll go to the front of that building to drop those victim impact statements off, okay?
We really just wanted to stay away from this.
I understand. Is it Mr. Trailer or is it Mr. Taylor?
It's Trailer, Your Honor. That's absolutely my name. I'm not sure where the Taylor is coming from, but the officers have my driver's license.
And are you a veteran, sir?
Yes, ma'am.
Of which armed forces?
The United States Army, ma'am.
All right. Mr. Trailer, there are additional resources available to you as a veteran. In the jail, you can you can inquire of one of the deputies about getting brochures that might direct you to some additional resources, okay?
Yes, ma'am.
And just for the record, you're charged with 2 counts of menacing.
Is he a vet? Do you guys think he's a vet?
Those are both class 1 misdemeanors. Those carry with potential penalties of up to 364 days in jail and or up to $1,000 fine. I do find that there are community safety issues in this case. For those reasons, I am in agreement with the prosecution that bond should be set in the amount of $1,000 cash or surety with the following additional terms and conditions, sir. You are to remain law abiding. You are to report to GEO Reentry Services within 24 hours of your release to be tested for drugs and alcohol at a frequency not to exceed 10 times per month. You are not to consume alcohol, drugs, or recreational marijuana. You must obtain court permission to leave the state of Colorado, and a protection order shall issue. The terms of your protection order are as follows. These are also conditions of your bond. You are to have no contact with Joshua Tennant and Max von Guldenstube. And I probably destroyed that name. I apologize. You are to maintain a minimum of 100 yards distance from them. You shall not harass, molest, intimidate, retaliate against, or tamper with any witness or victim of the acts you're charged with committing. You shall vacate the home of the victims and stay away from any other location they are likely to be found. And you shall refrain from contacting or directly or indirectly communicating with the victims in this case. You additionally will need to appear at your next court appearance and all future court appearances in this case. Your next court appearance is scheduled for August 20th, 2025 at 9:30 a.m. And if you need the further services of a public defender after you are released, you need to submit an application for a public defender within 7 days of the date of your release. I am additionally authorizing a Bridges referral in this case. Sir, this is not a Bridges referral is merely a referral. It's not an order of the court. What I am doing is I am opening up the door to allow mental health and substance abuse resources should you need them. You can either accept or reject the assistance from Bridges. You would a Bridges liaison, a person would reach out to you and speak with you about what kind of resources you might need. Again, you can participate or not. It's entirely up to you. But your next court appearance is August 20th at 9:30 a.m. Do you have any questions about any of that, sir?
And Your Honor, I'm sorry to interject. This is Mr. Short. Is there any way we could have Mr. Taylor be seen by the court sooner than the 20th, just given the amount of time? Or is that the soonest next in custody date we have?
I can set him on a public defender day. I was setting him on arraignment day, but I can set him on a public defender day.
I'd appreciate that, Your Honor. I just don't know if he's going to be able to post the bond, and I'd rather have him seen by the court sooner rather than later, given the issues that we've discussed.
All right, why don't we set him for, we're going to set the court date for August 5th at 10:30 instead. So that's August 5th at 10:30.
Thank you. We appreciate that. Sorry to interject.
Okay. Sir, do you have any questions about any of that?
Oh, no, Your Honor, I do not.
Okay. All right, then you're all set, sir.
Okay.
Thank you. All right. Again, if you have anything in your victim impact statements, you would take that directly to the prosecution's office, okay? And a protection order is in full force and effect. If there's a violation of the protection order, you need to contact law enforcement immediately.
Okay,
Okay?
thank you very much.
You're welcome.
Thank you, Big Man, for subbing. Thank you, Eric, for subbing on Twitch. Now you can watch it ad-free.
Next case is 25M396, People versus Jacayla Merritt.
Your Honor, this is Grayson Jordan on behalf of Ms. Merritt. Ms. Merritt appears in custody from the Eagle County Detention Facility on a warrantless affidavit alleging a single count of Class 1 violation of a protection order. We would waive further advisement as to this matter.
All right. Ms. Merritt, can you please state your name for the record?
Yes, my name is Jacayla Merritt.
Ms. Merritt, did you have a chance to watch a video that advised you of your rights?
Yes, ma'am, I did.
Do you have any questions about your rights?
I do not.
All right. And in this case, you are charged with one count of violation of a protection order. That's a Class 1 misdemeanor. Carries with it potential penalties of up to 364 days in jail and or up to $1,000 fine. Mr. Kerwin, would you like to make an argument for bond?
Upwood, Your Honor. Merritt is on a $1,000 PR bond in 25M5014. She's charged with assault third and criminal mischief as acts of domestic violence. In that case is set for August 19th at 10 a.m. The victim says he has no issues concerning safety or retaliation. He says what he wrote in his information for the victim advocate at the sheriff's office was that he thought Ms. Merritt needed classes or something to help her so she can embrace getting help, but she's not a big threat. Because of this most recent case, the P for $1,000 cash surety, please.
And just for the record, is Chris Milet present? All right, Mr. Short, go ahead.
Your Honor, Ms. Merritt is and was primarily a resident of Athens, Georgia, before meeting the victim online and moving out some years ago. And the accusations in the other case kind of deal more with that issue. What I'd like to highlight for the court in this affidavit is it looks like the two of them may or may not have gone to Las Vegas, and it's unclear whether that happened before or after the other case. The other thing I would like the court to take note of is the victim's birthday in 1983 and Ms. Merritt's birthday in 2002. Ms. Merritt primarily lives in Georgia with her family in Athens, and it sounds like traveled out here to work for the victim who may or may not run a dog grooming business. Ms. Merritt has a 12th grade education, is dealing with some mental health issues that are not significant, but relate to depression and anxiety. She would like the court to consider the fact that she only has $180 right now, and take that into account when setting her bond, understanding the other case is pending. She was actually before the court yesterday on the 22nd during our very long docket via WebEx, and has been making all of her court dates. understanding that this is of concern for the court, given the bond statute calling for the court to consider compliance with its orders. We're asking the court to take the other aspects of this case and her condition into account and consider a personal recognizance bond. Ms. Merritt's intentions would be to travel back to stay with her family in the state of Georgia, if so permitted by the Court of Appeal.
All right, thank you. All right, Ms. Merritt, what I'm gonna do, I do find some community safety issues. I understand what the victim's position is. However, there are some issues, obviously, that are occurring, as can be seen within the affidavit of warrantless arrest. So I'm gonna set bond in the amount of $1,000 cash or surety, but I'm also gonna authorize a cash equivalent just in case you're not able to obtain the services of a bondsperson to help you. So I would authorize a $100 cash bond as well. I will impose the following conditions of bond. You are to remain law abiding. You must obtain court permission to leave the state of Colorado. You're going to be able to go back to Athens. You just need, you'll just need to submit a written request and tell the court exactly where you're going to be. And then we need to run that, prosecution needs to run that by the victim. So it's a little bit of a process. You need to make sure that you do that in advance. And then a protection order will issue in this case. And this is going to deviate a little bit from the other case, because I do not think it is in anyone's best interest for you to be in contact, telephone or otherwise, with Mr. Milik. You are to have no contact with Chris Milik. You are to maintain a minimum of 100 yards distance from him. You shall not harass, molest, intimidate, retaliate against, or tamper with any witness or victim of acts you're charged with committing. You shall refrain from contacting or directly or indirectly communicating with the victim. So keep in mind, just no contact. It's probably beneficial for both of you. Otherwise, we end up in this situation. You also need to appear at your next court appearance and all future court appearances. I'm going to set this case with your other case on August 19th, 2025 at 10 a.m.
Okay.
If you need the further services, with this case, you just need to make sure that your application with the Public Defender's Office applies to both these cases. I am also going to authorize a Bridges referral. The Bridges referral is not an order. I'm not mandating you do anything with respect to that. What I'm doing is I'm opening up the door to mental health resources should you wish to utilize those. So you would be a Bridges liaison, a person would be in contact with you to talk with you about what you might need. You can participate or you don't have to participate. It's entirely up to you. I'm just opening the door for resources for you.
Okay.
Do you have any questions about any of that?
Also the bond, I was a little confused about the bond.
The end result really is a $100 cash bond, okay?
Okay. And I think they deposit my cash on the card.
And you can talk to the jail about that, okay?
Okay.
All right.
Okay.
Any further questions?
No, ma'am.
All right, you're all set. Thank you. Next case is 23M397 People versus Nathan Smith.
Yes.
All right,
Hello.
Mr. Smith. Hello, can you please state your name for the record?
My full name is Nathan John Smith. I go by Natron as my nickname.
All right, I'm going to call you Mr. Smith if that's okay.
Yes,
Mr. Smith.
that's perfect.
Excellent. Mr. Smith, did you have a chance to watch a video that advised you of your rights?
Yes.
Do you have any questions about those rights?
No.
All right, in this case, you are charged with first degree trespass of an auto with an intent to commit a crime. That is a class 1 misdemeanor. It carries with it potential penalties of up to 364 days in jail and or up to $1,000 fine. You're charged with criminal mischief, which is a petty offense. In this case, it carries with it potential penalties of up to 10 days in jail and or up to a $300 fine. You're charged with theft of auto parts. That's a class 2 misdemeanor, carries with it potential penalties of up to 120 days in jail and or up to a $750 fine. And you're charged with theft parts and accessories from a vehicle. That's also a class 2 misdemeanor with those same penalties. Mr. Short, are you appearing on behalf of Mr. Smith for the purposes of bond today?
Yes, Your Honor, we would waive further advisement by the court.
Thank you. Mr. Kerwin, would you like to make an argument for bond?
Oh, Your Honor, thank you. Mr. Smith also has pending 25 CR 138. That is set July the 30th at 9:30 in the morning. In that case, Avon police originally charged him with second-degree burglary. He's accused of going into the store at the West End Hotel there in Avon, or I'm sorry, it's the Sheraton, and stealing on 2 separate occasions bottles of wine. He is on bond in that case. Now we have him charged with additional theft offenses. The people are asking for a $500 cash bond because of his obvious inability to comply with bond conditions. I can't recall whether or not there was a Bridges referral in the 25 CR case, but it might be appropriate to do so. I suspect Mr. Smith may have an issue with substance abuse, whether that's alcohol, drugs, or both. Thank you.
No, not at all.
Mr. Short?
Not at all. Sorry.
Mr.
Your Honor,
Short, go ahead.
I'd like the court to take into consideration the fact that Mr. Smith is a 36-year resident of Colorado. He primarily earns his living as an artist. The apartment at issue that I think I've spoken to the court about in his other cases is one that he's lived at long enough for to have some kind of rent control. It sounds like he and his family have been talking to bonds people and kind of coming up with a way to solve the problem that is resulting in Mr. Smith having all of these cases. And the family's thought about that as perhaps getting Mr. Smith out of bail and somewhere with more robust services would be helpful. And I think that would be a good idea. And we think Bridges would help with that. And so we're just asking the court to take his financial condition into account because Mr. Smith has no money. He's asking the court for a PR bond.
All right.
Can I say something?
I am concerned. What would you like to say, Mr. Smith?
Oh, that I live in Avon and I'm going to be moving to Vail, back to Vail, where I lived for 35 years, and I never had any problems there at all. Never criminal. The only thing I ever did was speeding, and that was it.
Yeah. Well, you were last before the court when I set bond in your last case on July 1st. And then only 21 days later, 3 weeks later, you're engaged in some additional criminal behavior, allegedly. I do find that there may be some issues that center around some community safety right now until you get some assistance. So initially, I'm going to set the bond a little bit higher, but I'm leaving the door open to, if you get some services, to lower that bond to assist you. For now, I am going to set bond in the amount of $2,000 cash or surety with the following additional terms and conditions, sir. You are to remain law-abiding. You are not to consume or possess alcohol, drugs, or recreational marijuana. Yes. You must obtain court permission to leave the state of Colorado, and a protection order shall issue. The terms of your protection order are as follows. These are also conditions of your bond. You shall not harass, molest, intimidate, retaliate against, or tamper with any witness or victim of the acts you are charged with committing. And you must appear at your next court appearance and all future court appearances in this case I'm going to set this case with your other case on July 30th, 2025 at 9:30 a.m. so that those are both together. I will also authorize a Bridges referral. A Bridges referral, that portion of this is just, it's not in order. All I'm doing is attempting to connect you with some mental health and or substance abuse resources should you wish to utilize them. You would have a Bridges person, a liaison, reach out to you and talk with you about what services you might want. And again, you're able, you can either accept or reject that assistance. I'm just opening the door for you just in case you would like those services, okay? If you need the further services of a public defender after you bond out, you would need to submit an application for a public defender within 7 days of the date of your release. Do you have any questions about any of that, Mr. Smith?
No.
All right. Then you're all set, sir. Thank you.
Well, thank you very much. You've been very kind, and I know I've been very bad. I want to apologize. Oh, and I wanted to say, I do have an appointment with a psychiatrist, and I'm going to be taking meds for my schizophrenia, whatever they say.
That's
and I'm also
great.
going to be Sarah Gabriel, who I had talked to for 4 years. She gave me some lithium and Wellbutrin that I had bad reactions to, and I stopped using her. But she is back, and I can have video chats with her. She's
so,
very
Mr.
nice.
Smith, I would definitely suggest that you keep in touch with them. Bridges can also help you do that. When you're initially prescribed, Bridges, the Bridges are.
Oh, okay, okay. I'll get the information, I'm sure, from them.
So when you start meds like that, sometimes they need adjusting because they might not feel good in some respects. So just really communicate with your doctors about what's working, what's not, so they can work with you on adjusting your medication, okay?
Well, I think it's the pharmacist that I really didn't have control of how much I take and tell me how much to take, right?
Your doctors do.
That's a doctor who says that. Yeah, you're right. Okay.
Yeah. Okay. All right.
Okay. Maximum respect. I appreciate. And yeah, thank you.
You're welcome. Have a good day. Okay. Next case is 25 CR 152, People versus Christine Sexton.
Your Honor, Grace and Short on behalf of Ms. Sexton, we would waive any formal advisement by the court. I appraised Ms. Sexton of the elements and penalties of the charges as laid out in the warrantless affidavit. We would ask the court to consider not finding probable cause on a class 3 felony burglary charge. But other than that, we're ready for bond argument whenever the court is.
All right. All right. Would the people like to, let me back up. Ms. Sexton, can you please state your name for the record?
Christine Sexton.
Ms. Sexton, did you have a chance to watch a video that advised you of your rights?
Yes.
Do you have any questions about those rights?
No.
All right. Mr. Kerwin, any thoughts on the second degree burglary?
So the other courtroom is like a courtroom right from hell. This is a dungeon with the big stone walls. She needs fire. She needs some torches on these walls. They're all in a great, big, gigantic dungeon today.
Burglary, that is, I did have some questions about the allegations within the affidavit about that charge.
Your Honor, I wasn't very clear about that either. I thought at the very least, perhaps it might be a criminal trespass in the first degree. So I'll agree that the affidavit is not clear as to what the facts are as to whether or not she actually was residing there. I think you can infer that she wasn't, but it is not clear. I agree with that.
Okay. All right, then for purposes of the affidavit of warrantless arrest, do not find probable cause in support of a second-degree burglary charge. That doesn't mean, Ms. Sexton, that it's dismissed. It just means that there's not enough information within the affidavit itself to substantiate that charge. Mr. Kerwin, would you like to make an argument for
Thank you, Fozzie.
bond?
I would, Your Honor. Ms. Sexton is currently on probation with Kendall Burnett in our probation office in 24M10 and 24M16. She has a previous DUI out of Garfield County, that's 24M232, and a domestic violence that is a successful deferred judgment out of Pitkin County, 22M130. It would appear that alcohol is a major problem for her. I'm pulling up the victim contact information from Mr. Cornefell, who is the protected party. He indicates he does have safety concerns, fear of retaliation. He says she has a major ability to control it. If she gets out today, she'll go straight to drinking. He didn't want her. I'm for $5,000 cash surety because of the felony menacing charge. And things in addition, bond, Your Honor, I don't know if probation has done this. I would ask to require a TAD or sober link instead of DO testing 10 times per month. He's being tested by probation, but that doesn't appear to be any restraint on Miss Sexton consuming alcohol. So I think a TAD or a sober link device might be appropriate as an additional condition of bond. Thank you.
All right, just for the record, is Matthew Cornefell present? All right, Mr. Short, go ahead.
So Your Honor, Ms. Sexton is asking you to take into consideration the fact she is on probation, as Mr. Kerwin identified. Most of her family lives in Orlando. She manages the Butch's Lobster restaurant, which I had never heard of until speaking to her, but I guess it's a popular lobster place here in the Valley. She's the manager there. She doesn't have any children, but she owns the condo at issue in this case, which was a little bit of where my probable cause argument was coming from. That's obviously something we'll figure out later. But she does have a residence here. Sounds like owns that condo. Her mom and her are working on what will happen with Mr. Cornefeld, because it sounds like all of his stuff is over there. And so if the court would help us with a civil standby so that Ms. Sexton could get any undisputed personal property, she would appreciate that. Otherwise, Your Honor, it sounds like Mr. Cornefeld isn't like on a lease and he's not on the deed or anything. But understanding that's something we'll figure out later. She has lived here for 12 years. She's got a bachelor's degree from the University of Central Florida. I think Ms. Sexton is dealing with something that is a leading cause of death for women over 35, which is alcoholism. And I think that TAD would be helpful for her in getting that issue resolved. I'll bring the court's attention to the conversation she had with police, where she talked about some issues with the victim, and also understanding what today is for and not for. The victim does have a felony conviction and a previous domestic violence conviction out of Pitkin County in 2019, 221 and 16 CR 68. So we're just asking the court to, and consider Bridges here as well. But for Ms. Sexton, we're asking you to not consider a bond more than $1,000 given her financial ability to pay.
All right. All right. I do find that there are community safety issues, at least at this point in time, without real safety nets that are in place. This is not a first domestic violence incident. There are significant issues as it relates to interaction with the victim that have yet to appear to be resolved. So the court is in agreement with the prosecution that bond should be set in the amount of $5,000 cash or surety. Just Additionally, the allegations in the affidavit are serious and alarming, and the court is also taking those into consideration that that this defendant, Ms. Sexton, is a substantial community safety risk, especially as it relates to Mr. Cornfeld. I will impose the following additional conditions on that $5,000 cash or surety bond. Ms. Sexton, you are to sign a waiver of extradition. You are to remain law abiding. You are to report to Geo Reentry Services within 24 hours of your release to be equipped with a TAD or a SoberLink device, one of the two. You are not to consume or possess alcohol, drugs, or recreational marijuana. You must obtain court permission to leave the state of Colorado, and a protection order shall issue. The terms of your protection order are as follows. You are to have no contact with Matthew Cornfeld. You are to maintain a minimum of 100 yards distance from him. You shall not harass, molest, intimidate, or retaliate against or tamper with any witness or victim of the acts you are charged with committing. You shall vacate the home of the victim and stay away from any other location he's likely to be found. You shall refrain from contacting or directly or indirectly communicating with the victim in this case. You shall not possess, purchase, or control a firearm or other weapon. You shall not possess or consume alcoholic beverages or controlled substance. That provision is necessary for the protection of the victim. You shall not possess or purchase any ammunition, and you shall relinquish all firearms within 24 hours of your release. I will authorize a civil standby. That is a legal mechanism that allows you to utilize the services of law enforcement to go back to the residence one time to obtain any items of personal belongings you might need during the period of the protection order. Because you are being charged with a crime that is alleged to be an act of domestic violence, it's a condition of your bond and a condition of the protection order that you neither possess nor receive firearms or ammunition during the period of your protection order. As indicated previously, if you have firearms or ammunition, you are required to relinquish those within 24 hours of your release. I will send a firearm affidavit to the jail. That is a document where you declare whether you have firearms or ammunition. You need to complete that before you are released. Your failure to timely complete that affidavit or to timely relinquish your firearms or ammunition could result in additional charges being filed against you, could result in your release on bond being revoked, or could result in you being contempt. You also need to appear at your next court appearance and all future court appearances. Your next court appearance will be scheduled for August 5th, 2025 at 10 a.m. The further services of a public defender after you are released, you need to submit an application for a public defender within 7 days of your release. Lastly, I will authorize a bridges referral in this case. Again, as you might have heard me tell some of the other individuals, this is not a mandated order for the bridges referral. I'm just opening up resources, the ability to take resources for you for mental health and for substance abuse treatment. A bridges liaison, an individual will contact you to speak with you about what you might want for services, and they'll help you connect with those services. Again, you can decline those services if you so choose. It's entirely up to you. Now, that was a lot of information. Do you have any questions about any of this?
Your Honor, it got kind of hard to hear the court at the end. I'm sorry, Ms. Sexton. Did the court do a civil standby?
Yes. Yes.
Okay. Perfect. Sorry to interject.
Okay. Ms. Sexton, do you have any questions about any of that?
No, ma'am.
Okay. All right, then you're all set. Thank you very much.
Thank you.
Thank you. Is there like orange folder there? We don't have an orange folder. Oh, sir, if you want to come up with your orange folder, we'll take care of that. Sure. There you go. And then you can head back to the podium there and we'll take care of this.
Good afternoon, Your Honor. He needs the interpreter. I thought I'll let you
All right,
know.
if you need the interpreter, sir, you want to put the headset on?
¿Se puede poner los auriculares, señor?
No. No están.
They're not there.
Oh, 1 second.
Un momentito.
I know they just said it, but I don't know what language this is. It could be Spanish, but I'm not sure. I don't think it is.
Okay. Give me a minute. Numbers 24T1077, 25T86, 24T1142, 24M609, 24T718, and 25T85. People versus Angel Esparza Landeros. Sir, I have before me plea paperwork for all of your cases. It is my understanding that you intend to enter into the following pleas. In case number 24T1077, you would plead guilty to driving after revocation prohibited. Upon your plea of guilt to that charge, any original or remaining counts would be dismissed. In 25T86, it'd be the same exact plea. You'd be pleading guilty to driving after revocation prohibited. The remaining charges would be dismissed. In case number 24T1142, you would plead guilty to driving after revocation prohibited. Upon your plea of guilt to that charge, any original or remaining counts would be dismissed. In case number 24M609, you would plead guilty to the charge of eluding a peace officer. Upon your plea of guilt to that charge, any original or remaining counts would be dismissed. In case number 24T718, you would plead guilty to no proof of insurance. Upon your plea of guilt to that charge, any original or remaining counts would be dismissed. And case number 25T85 would be dismissed. Is that your understanding, sir?
Yes.
Yes, that's right.
All right. I see that you've signed plea paperwork. Did you read through all of the plea paperwork before you signed it?
Sí.
Yes.
And did you go through the potential penalties associated with entering into this plea that's set forth within the plea paperwork?
Sí.
Yes.
And did you go through the rights available to you on the front page of the plea paperwork, sir?
Sí.
Yes.
You understand that by entering into this plea, you waive most of those rights?
Sí.
Yes.
Okay. And you always have the ability to be represented by an attorney if you would like an attorney. We would continue this case to allow you to get one, or you can proceed forward today. The choice is entirely yours. What would you like to do?
Seguir a la sentencia.
To move forward to sentencing.
All right. Okay. Last couple of questions, sir. Is anybody forcing you to proceed without an attorney today?
No.
No.
Is anybody forcing you to enter into a plea today?
No.
No.
Are you under the influence of any substance that would affect your ability to make a decision?
No.
No.
All right, then how do you plead? Let's go case by case. In case number 25T86, how do you plead to the charge of driving after revocation prohibited?
No culpable.
Guilty.
In case number 24T1077, how do you plead to the charge of driving after revocation prohibited?
Culpable. Guilty.
In case number 24T718, how do you plead to the charge of no proof of insurance?
Culpable. Guilty.
And in case number 24M609, how do you plead to eluding a peace officer?
Culpable. Guilty.
Are you saying not guilty or guilty?
Culpable. Guilty.
Okay. All right. Case number 24T1142, how do you plead to the charge of driving after revocation prohibited?
Culpable. Guilty.
Would you like to tell me what happened? You don't have to, but you can if you want to.
¿Con cuál caso? In which of the cases?
In any of them.
Pues iba manejando sin licencia. Well, I was driving without a driver's license.
All right. I accept your plea of guilt in all of these cases. I find that your plea's been entered into knowingly, voluntarily, and intelligently. You've waived your right to counsel knowingly, voluntarily, and intelligently. And you've told me a little bit about what happened. I will dismiss case number 25T85. Would you like to make any statements before I issue a sentence in these cases, sir?
No. No.
Okay. All right. So.
Did you miss that last case? Kicked at that lady was crazy. She messed that guy up. Yeah. Women are crazy.
Your plea offer in these cases, we just have to trying to figure out the best way to do this. Is that I think the end result is they want 60 days of jail completed. The way that they've written some of your pleas, it is in violation of the mandatory minimums. However, I think I can get through it. I can get by that by framing your sentencing in a little bit of a different way. End result still being that you serve a total of 60 days in jail and no more. So just keep that in mind and we'll go through everything at the end. In case number 25T86, I'm going to sentence you to 30 days in jail. No credit for any days served. I will not assess a fine. I will impose standard court costs. No restitution is requested, none is ordered. This jail sentence will be consecutive to your jail sentence. In 24T1077. In case number 24T1077, I'm going to sentence you to 30 days in jail, no credit for time served. A jail sentence will be consecutive to 25T86. I will not assess a fine. I will impose standard court costs. No restitutions requested, none is ordered. In case number 24T1142, I will sentence you to 30 days in jail, no credit for time served. That's jail sentences to run concurrent with case numbers 24T1077, and 25T86. So consecutive means, so the first two cases are consecutive, meaning they run one after the other. The last driving after revocation charge is concurrent, meaning it runs together with the other two cases. So the end result is you only serve 60 days in jail, okay? I will not assess a fine. I will impose standard court costs. No restitutions requested, none is ordered. In case number 24T718, that's your no proof of insurance charge. The minimum fine in that case is a $500 fine. I will assess a $500 fine plus standard court costs, no restitution requested, none is ordered. I will not sentence you to any jail in that case. Your final case is 24M609. That's eluding a peace officer. In that case, I will not sentence you to any jail. I will not assess a fine. I will impose standard court costs. I will, bear with me. I will place you on unsupervised probation for a period of 12 months. Terms and conditions of your probation are that you remain law abiding and you complete 60 hours of useful public service within that 12-month period. No restitutions requested, none is ordered. Again, that last case, 25T85 is dismissed. How much time do you need to report to jail, sir?
No sé cuánto tiempo usted puede darme. I'm not sure how long can you provide me? Can you give me?
It depends. What are you doing with your time?
Quisiera, bueno, para juntar un poco de dinero, para mandar a mi familia en México para esos 2 meses de cárcel. Estoy trabajando ahorita. I would like to have a little time to gather a little bit of money to send to my family in Mexico before serving the 2 months of jail. I'm working right now.
Okay, would 30 days be enough, sir?
Sí, está bien.
Okay.
Yes, that's fine.
All right. Then I'll issue a stay of execution on your jail sentence to August 23rd, 2025 at 4 p.m.
I'm sorry, Your Honor, can you say the date again, please?
August 23rd, 2025 at 4 p.m. And after you leave here today, if you head down the hall to the right to the court clerk's window, they'll tally up your fines and court costs. If you need time to pay, just ask to be placed on a payment plan. Do you have any questions about any of that?
Sí, entonces la sentencia final de todos los casos, de todos los cargos que tengo, lo final son 60 días de cárcel, o sea, lo final. Yes, so in altogether in all my cases, the final sentence is 60 days of jail. That's the final.
Yep. You have really in total, you have 60 days in jail, 60 days useful, 60 days useful, you'd be working forever. 60 hours useful public service, a $500 fine plus standard court costs. Okay. Do you have any questions about any of that, sir?
No, es todo.
No, it's all. All right, then you're all set. Glad you were able to finally reach resolution in all of your cases.
Sí.
All right, have a good day,
Yes.
sir.
¿Cuándo sería la entrega para anotarle? And I'm sorry, when is that I need to turn myself in to write it down?
August 23rd at 4 p.m.
Okay, gracias.
Okay, thank you. You're welcome. Have a good day.
Thank you.
All right, we're going to start problem-solving court here in a minute. Just for the record, live streaming court proceedings can harm our participants.
Yeah. That would be an interesting court to get, but we don't get it. All right, guys. Thank you so much for coming out. I really appreciate it. I shall see you guys again very soon, in like 2 minutes even, in O.J. Simpson. Have a great day, guys. Bye.
Got these life echoes, digital dreams. Through the screen, her blue eyes gleam. Wicked humor, sharp as a knife. Her stream sparks electric light. Late night when the world sleeps, she's the friend that always keeps. Giggles roll like thunder loud. She stands out in any crowd. Kathy's laugh cuts through the gloom. Eyes blue like a summer's bloom. Her humor dark and twisted sharp. In a way, there's no alarm. Streaming tales late into the night. Her laughter feels just right. Even when my world turns gray, with a giggle, she lights the way. Her eyes hear a sky so blue. In her jokes, there's a truth so true. With each stream, she brings the light. Turns dark days into bright. Kathy's laugh cuts through the gloom. Eyes blue like a summer's bloom. Her humor dark and twisted sharp. In a way, there's no alarm. Streaming tales late into the night. Her laughter feels just right. Even when my world turns gray, with a giggle, she lights the way. Kathy's laugh cuts through the gloom. Eyes blue like a summer's bloom. Her humor dark and twisted sharp. In a way, there's no